Good afternoon, everybody, and welcome. I'm Steve Allegrezza. I'm Executive Director of IHFRA, and I'm really glad that you've taken some time to join us today. We know that the world of independent sales reps could be incredibly rewarding, but it also can be incredibly complex. So one of the things that we hear about most often is around reps and their contracts, how to negotiate them, how to protect yourself, how to make sure the work you do is valued and compensated fairly. So for today, our webinar is designed to give you the tools and confidence to do just that. Over the next hour, we're going to tackle some of the most common pitfalls reps face when negotiating contracts, and more importantly, how to avoid getting stuck in one-sided agreements that don't serve your business. So for today, here's what you can expect. We're going to start with some of the foundational insights and real world examples from our guest expert, and then we'll open things up for Q&A towards the end. So as you're listening, you are always welcome to drop your questions into the chat, and then we'll make sure that we get to as many of those as possible in the Q&A. So with that, it is my pleasure to introduce today's speaker, Adam J. Glazer, the managing partner at Schoenberg, Finkel, Beederman, Bell, Glazer, LLC, which is known as the go-to law firm for sales reps nationwide. Adam is one of the most respected voices in the country when it comes to representing independent sales reps. He is an experienced trial lawyer who has successfully taken cases ranging from complex contract disputes to high-stakes business litigation to verdict in both state and federal courts. He's been recognized by attorney organizations as a leading lawyer and a super lawyer, and he dedicates a significant part of his practice to protecting the rights of independent reps nationwide, including recovering millions of dollars in unpaid commissions. So beyond the courtroom, Adam is an adjunct professor at Northwestern University's Pritzker School of Law, where he teaches civil discovery and business litigation. And he's a regular contributor to trade publications across the industry and does a heck of a lot for organizations like IHFRA. So we're incredibly thrilled to have him with us today to share his expertise and practical strategies for leveling the playing field when negotiating contracts. So please join me in welcoming Adam Glazer. Adam, the floor is yours, sir.
Okay, thank you, Steve. It's always great to be with you. It really is an honor to have this opportunity to speak to the IHFRA members. I do want to jump in and get started on this, but Steve, do I have the, let me see if I can do this again here. Okay. All right, it says I'm screen sharing now, so
there we are.
Thank you. I hope everybody with us today remembers Animal House, and it was an important part of a lot of our lives. So you remember the line, "Thank you, sir. May I have another?" That's the derivation, although I've tried to update it a little bit here. You see it also has some application, and sometimes as a sales rep, you can see yourself playing the squid game as well. But it refers generally, of course, to the unfair negotiating position that sales reps find themselves in all too often, especially with the big guys, when you are trying to get any kind of fair underpinning for your contracts. And we're going to talk about various contract terms, and we're going to dive in if it's okay. You know who I am now due to Steve's very generous introduction, so I don't have to go over that. Instead, let's get started. The relationship with your principals, your suppliers, it's supposed to be a true partnership. The world that should be, where two partners sit down, you negotiate, you come out with a reasonable contract, a contract that perhaps neither side is completely happy with, but one that represents some compromise, some give and take. Because after all, your roles are the same. You share the same goals. You're trying to go to market together. Think of Batman and Robin. You're supposed to be in that same role side by side in the marketplace. However, the world that often is, especially with some of the big boys like Ashley, makes that very tough. And I understand that, and I know that not everything that we're going to talk about this afternoon is going to be doable. It's going to be very difficult for some of this to actually get through, but we're going to do the best we can to go over some of these terms and discuss contract positions so that perhaps progress can be made. After all, if you don't get a principal who is willing to talk to you, you have to ask yourself about the whole beginning of the relationship. Is it what you really want, or are you going to end up, like Kevin Bacon in Animal House, where you just have to bend down and take it? And of course, that's a role that may be necessary, but certainly is undesirable. Question, is sometimes asked, why? What's the point of this? Why do I bother negotiating? Just in case things go wrong and I end up in court or in front of an arbitrator, everybody's going to know that this wasn't something that I had equal bargaining position with. It was the big manufacturer versus the little sales rep. They're going to know I had no choice but to sign this contract if I wanted the business. But I'm here to tell you that unfortunately, these agreements, if you sign them, or even if you enter into an oral agreement, they're going to be enforceable. The exceptions are very difficult to prove. It was a fraud. You didn't know what you were signing, not because you didn't read it, but because they led you to believe it was something other than what you had an opportunity to read for yourself. The agreement is so ambiguous, nobody knows what it means. That might be an exception. Or another difficult exception is to try and say that the agreement that you freely signed is against public policy of a state. What about duress? I get that asked about that a lot. Adam, I had no choice. If I wanted the line and I wanted to be able to pay my people, I had to sign their contract. Generally speaking, duress isn't a defense. Duress means you quite literally had a gun pointed at your head. That is duress. The idea that you were in a bad business position is not a defense to signing an agreement, nor is unfairness. This is what I get all the time. Look, Adam, read it. Take a look at it. You see how unfair this is to me. Unfairness, unfortunately, won't get you out of a deal. Courts will view sales rep organizations as being a commercial entity, and they will look at your relationship with your principal as between two sophisticated businesses. It's very difficult to convince a court that a contract is so unfair that it shouldn't be enforced. Now, the next question that I get asked a lot is to say, well, why would the principal negotiate with me? I'm just a little sales rep. They have their form agreement. Why should I even think that they will negotiate? I'm here to tell you that despite the initial response you will sometimes get, many of these principals, even if they have a form contract, they will listen to what you have to say. After all, they want you. They're there because they want you, not another rep. Some of them actually believe in a consensus. They believe that it's important to have you vested, that you're not just signing a contract they're forcing down your throats, but this is a contract that you want to enter into. And remember, you're sitting there with this opportunity and not a different sales rep for a reason. The reason is they want you, and to get you, they are oftentimes, not always, oftentimes willing to compromise. And then you have to ask yourself, well, if they tell me it's my way or the highway, sign the agreement or I'll get another rep in here who will, is that the kind of business partner that you want to start out with? Is that a relationship that you actually want to proceed with? Ordinarily, you'll end up perhaps not getting everything you want, but maybe if you can find 2 or 3 provisions that are particularly important. There are different negotiating strategies. Maybe you start out by asking for a lot more than the 2 or 3 you really want, but you zero in on the 2 or 3 in the hopes that you can make some progress. Now, I know what we're going to talk about today is largely the written agreements, but most of you have oral agreements. I know how common oral sales rep agreements are in the furniture industry. I get questions about them all the time. But you have to recognize, first of all, every state will enforce an oral contract. A lot of you think that a contract that you have with a handshake is not really a contract. And a lot of calls I get start out to say, I don't have a contract. Well, you do have a contract. You have an oral agreement. You've been repping the line probably for years, and it's not just on a whim. It's because you have reached a certain agreement, and that agreement from the time that you struck it has been modified by your course of dealing with them, all of which provide terms that courts will enforce. Now, there are some differences between pursuing a claim under an oral contract and under a written contract. Most significantly, the statutes of limitations are typically shorter under oral contracts, meaning you have less time to assert a claim if it's an oral contract rather than something that's in writing. And the reason for that is courts recognize that memories fail, and it's harder to introduce proof of the terms of an oral agreement than it is a written agreement. So they try and encourage that claims under oral agreements are brought more promptly. But oral contracts are sometimes better than a written agreement. I can do a lot with an oral agreement because there's a lot to be filled in under principles of law, whereas a written agreement that is heavily slanted in favor of a manufacturer may rule out a lot of the claims that we would otherwise be able to assert. So I'm not at all put off if there's a handshake deal rather than a written agreement. It just involves different aspects of proof, but it's nothing that we can't proceed on, and it's nothing that you should look at as if you don't have an enforceable deal. We're going to talk mostly about terms in written contracts, but a lot of those written terms apply in oral agreements as well if you've reached these terms orally, either at the beginning of the relationship or if these terms have come to be applied to your oral agreement. But when you're dealing with a written agreement, I have 4 rules for you. The 4 rules all involve the same thing. Number 1, you have to read the agreement. It's the most important agreement, most important rule I have for you. You can't just sign it without looking at it, without recognizing your obligations. And you're going to see that later in the presentation, what happens sometimes. But you have to read the agreement, and you have to read it before you sign it. The rule is so important that it actually comprises rule number 2 as well. You have to make sure that you understand what you're getting into, and then recognize that the terms, you may not like them, but this is, after all, in many respects, an opening offer. You have the opportunity to push back. You are valuable to them. You are most valuable before you sign the agreement because they're negotiating with you. So you have a chance to improve what they've offered you. And rule number 4 leads to the same thing. You are a sales professional. Negotiate while you still can. It's a lot easier to negotiate up front than to get into the relationship and try and negotiate an amendment. Now, when you get into the relationship and when you start, with the contract, probably the first thing you have to look at is, are you the exclusive sales representative? Do they have the right to put other reps in your territory? Do they have the right to compete against you themselves in your sales territory? This is a term, all of the terms that I'm going to put up, by the way, come from contracts in our office, contracts from sales reps who have brought claims or have asked about their potential claims. So this is a not uncommon provision. This says right up front, you are a non-exclusive sales rep. Now, maybe that's okay. Maybe that's the way your relationship has always been, or maybe that makes sense from a business perspective. I'm not here to tell you you can't sign a non-exclusive relationship. Just understand from the beginning what that means, because it has an effect on a lot of what you're going to do. The norm in many industries is for sales reps to have exclusive territories. The concept there is both sides want you to be out there in the field promoting the manufacturer's products, which you can focus on exclusively if you have an exclusive arrangement. If it is a non-exclusive deal, you're not only going to be selling, you're not only going to be out there working the field, but you're also going to have to spend a good deal of time back at your computer trying to lay claim to certain sales. You're going to have to monitor the sales activity. You're going to have to make sure that another rep doesn't get credit for your work, or the house doesn't fail to acknowledge that you were behind the sales. So the preference is, of course, to make sure that you're going to get paid on all sales into the territory. But if that's too hard to get, and it's okay with you to have a non-exclusive relationship, just recognize how that's going to impact going forward. And many of you, of course, are already there, and you're comfortable with it, and that's great. So commission payments are one of the most important terms, of course, to a sales rep. And there are different approaches that all of you who have written contracts say about your sales relationships and your commission rights under those relationships. This is a classic provision, paragraph 8A here on the left. And it says that the sales rep is going to earn his commissions when the company receives payment from the customer. So that is one approach. But a preferred approach that we recommend provides that you're going to get paid your commission following the month in which the invoice issues. Principals will tell you that's not fair. If we don't get paid, how can we possibly pay you? As a sales rep, you have to recognize, and your position can be, I don't control payment. That is up to you to make sure that you get paid. I have fully performed as a sales rep. I have done everything I can humanly do by getting you the PO from a company that you decide to do business with. So I have, upon my full performance of my duties, I have earned the right to get paid. And if you can, and I'm not saying this is easy, you want to go a little further and put into the agreement that, again, for an exclusive territory, that you're going to get paid regardless of whether you were the procuring cause of that order. If the order comes from your sales territory, it should be commissionable to you. Here's some other language as well. A different contract, note paragraph 5B here. It specifically says due and payable following the month in which the manufacturer is paid. That's a not uncommon approach. It's not what we prefer. When a order is accepted by the manufacturer is preferable language. When the invoice issues, when the order is accepted, again, you have done the work that you have to do. So if you're able to negotiate language like this, if you're able to obtain language that makes sure you get paid without having to worry about circumstances beyond your control, the next thing you have to focus on in your contract is there a provision in there that holds the door open to change? You've successfully obtained your commission rights, but is there a language like this that's in the agreement elsewhere that says the commission program will be updated from time to time? Doesn't say with agreement of the sales rep. It doesn't say upon consideration paid to the sales rep. It says it will be updated, and the company will simply provide you with notice of changes to the agreement. So you may work your butt off to try and get language in there that is fair to you about getting paid, or even about the commission rate. But if you have a section like this in the agreement, it means they can unilaterally change the terms simply by giving you notice. And again, that's not the notice they would give you would be to change it to a condition that you probably wouldn't have accepted if it had been in your original agreement. This is not remote. This happens all the time. There's a new regional manager who takes over. Maybe the company is sold and you have a different way of doing business now, a different approach, and the new owner or the new manager looks over the existing contracts and doesn't like the terms that are in there, says, I never would have agreed to that. I wouldn't have paid him a commission that generous. I wouldn't have said that I'm going to pay him upon shipment or upon invoicing. And they try and change it, and they find this paragraph, and this is the vehicle that they use to try and get there, to try and say that we're going to change everything now. You got 30 days notice. So consider whether this is a provision that should remain in the contract. Other terms I want to get to, and I know Steve isn't giving me too much time, so I'm going to try and get through this pretty quickly. Each contract typically lays out the responsibilities of the sales rep. And this, what I have in front of you here, is a classic provision that is entirely reasonable. We have no issue with this. This provides certain responsibilities and even goes a little further and says if you don't sustain these responsibilities, then it's grounds to declare you in breach of the contract. And again, it's nothing that's onerous. It's nothing that you have to worry about. It's entirely fair to have a provision like this. What's unfair? Take a look at this. This is coming right out of another rep contract. I assume that nobody on this call would ever sign a contract that has this sort of ridiculous provision in it, calling for you to personally visit every account within 180 days, every account in the territory. I mean, this is the kind of nonsense that perhaps a new sales manager thinks is going to score him points with his boss, or thinks that the sales rep is just going to sign whatever I put in front of him. This is not something that I hope anybody would actually sign. It's just the danger, and it speaks to the importance of rules number 1 and 2 that I gave you of reading the contract before you sign it. You don't want to get stuck with something like this. Now, another important provision that I want to just quickly go over with you talks about an accounting. Too many rep contracts that I see do not say anything about the sales rep receiving a regular commission report. And it's just not appropriate that the contract not require delivery of a sales report, a commission report, an accounting, a reconciliation statement, whatever you want to call it. I just want you to make sure that your sales rep agreements, when you do have written agreements, or even when you negotiate for an oral agreement, you should negotiate to make sure that together with your commission check, you're going to get a regular accounting that enables you to reconcile the monies that you're receiving with the sales that you've accomplished during the previous month. So recognize how important an accounting is. Another provision you got to look out for, of course, are house accounts. These are handled differently by different principals. Here's a provision that says it is expressly agreed. So you have given up your right to complain, because after all, it says you have expressly agreed that the company in its sole discretion can take accounts away from you. It doesn't say that there's any conditions on this. It doesn't say that you are to receive anything in return. You spent the last 10 years building up this account. It's now one of the most significant accounts for the principal. And if you have a contract with language like this, they don't owe you a dime when they take the account away from you, because after all, it says you've expressly agreed to this. This one goes even further and spells out you get nothing, shall not be entitled to any commission for sales by company to any house accounts. So they have every right to treat you unfairly if there's a provision like this in your agreement. Here's another way of doing it, and this one's a little bit sneaky. If you read this provision, it says you get paid on everything. The commission gets paid on all sales, but it says no commission shall be paid on sales to the following accounts. So it gives them the right to designate house accounts. Here they're called protected accounts, but see how it says none? Oops. It says none on there. So that means that they are not designating any house accounts. However, the next sentence, which I've highlighted for you, says company reserves the right to add accounts. And all they have to do is send you written notice. So even if you think you're starting out fairly, because after all, there are no house accounts in the agreement, with language like this, it goes back to the idea of holding the door wide open. They have the right unilaterally, without any compensation to you, to take away your biggest account, an account without which you probably wouldn't have entered into the relationship in the first place. So you got to look out for language like this. What it should say, and I'm not saying this is easy, I don't want to sound like I'm naive about this, but what it should say, what a fair agreement would say, that both sides recognize conditions can change, things aren't going to stay the same year to year, and there may be a need down the road to change certain accounts to house accounts. And this doesn't say they can't do it, but what it says is it can't be done unilaterally. The rep has to receive valid consideration for taking away an account. So that essentially means you have to be consulted and you have to give your consent. So if there is an account that needs to be a house account, it has to be negotiated. That's what this means. There has to be an ability for the sales rep to weigh in, to be heard about this, and to be treated fairly. Now, a big issue that comes up a lot is the subject of reporting. It has changed a lot over the years, the requirements, but take a look at language like this. This is out of a recent contract where it has the rep agreeing to submit a quarterly listing of all new and active customers, furnishing the company requests for proposals, names and addresses of customers. This is the kind of stuff that is grossly unfair. This says that the rep is just a vessel and you have to turn over all your intellectual property, all of your protected materials to the company upon demand. And even if it doesn't start out that way, even if the relationship starts out with a regional sales manager who respects you and recognizes your importance. If there's language like this in the agreement, it means that manager's successor could step in who doesn't know you and doesn't respect you and doesn't value you and could expect a download on all of your information. Contracts like this provide for submitting monthly or quarterly reports of information. This is essentially a improper request that you not only relieve yourself of your confidential information, but it also requires, again, that you spend more time at your desk working on reporting, working on collecting data, preparing spreadsheets, sending the information to your principal rather than being out in the field trying to promote the products. So there are various reasons why this is a bad idea, but one of them is that if you have requirements like this that are ordinarily only expected of employees, not of 1099 independent contractors, there is the potential that the government, the Department of Labor or the IRS or state agencies will look at this and say, wait a minute, this doesn't speak to having an independent contractor relationship. This makes it sound an awful lot like you are acting as an employee with these kinds of requirements and these sorts of expectations. And that, of course, is not in either side's interest. If there are too many factors that evidence a sales rep is serving in an employee capacity, then all of a sudden the company can be directed by the Department of Labor to treat you like an employee. And that means you're going to get a salary, you're going to get benefits, you're going to receive a 401k, you're going to drive a company car, you're going to get a cell phone. Think about all of the implications if you are an employee. And it should be enough that the manufacturer will push back and say, okay, wait a minute, hold up. I'm not going to insist on all of that. Sometimes they have to be educated to this. They have to understand the implications of imposing these kinds of reporting requirements on an independent contractor, just like they should be careful about any other imposition of requirements on you, like telling you, who to call on, when to call on them, or directing how you're going to call on them, or what employees of are going to go with you to call on these people. These are not the kind of requirements that are applied to independent contractors, only to employees. Now, the standard for this changes an awful lot. Under the last administration, the standards tilted a lot more in favor of independent contractors. It hasn't happened yet, but there is the expectation that the current administration will try to tilt those factors back toward the employers, the manufacturers, and away from employees or independent contractors. So everybody has to pay attention to this. But the reporting is a very dangerous requirement, and it's a road that if they understood what they were doing, most principals would not want to go down, not want to impose too many reporting requirements. Another very important provision in a contract is termination. What are your rights upon termination? This one says, of course, that you're signing a 30-day contract. Doesn't matter what it says at the beginning about this contract being a 1-year or a 3-year contract. If there's a 30-day termination right, which is not uncommon, it essentially is a 30-day contract. But what it says further is that upon termination, they're going to pay you on the POs placed up to the effective date of termination. This is very unfavorable language for a sales rep. That means if you spent the last 2 years working on a particular customer to get that customer to change and to buy its furniture from a line that you represent, and you're that close to picking up the PO, and the principal knows that, and they terminate you before the PO comes in and make sure that it doesn't come in until after your termination is in effect, it means that all of that work that you put in for the last 2 years may not get compensated, because language like this says up to the effective date of termination. The order that comes in the next day, the principal will argue, is not commissionable to you. Here's another provision that says that the principal has the right to terminate you and in its sole discretion can cancel your entitlement to all or a portion of your commissions. Now, this one talks about a successor sales rep, that if they decide they want to pay your successor on that business, then they can take it away from you, even though you've done all of the work. But again, the dangerous component of all of this is that it's entirely in their control. They have the discretion. It's not a joint decision. It's nothing that you can contribute to. You're basically turning over your rights to commissions upon termination with language like this. There are other ways to do this, of course. I know this is going to be a little bit hard to read, but this comes out of another rep contract. I cut and pasted it because the language here is so significant. This talks about commissions that should be paid for the life of the part, life of the product. Now, that doesn't apply in every situation, but where you were involved to a significant extent, not only in landing the customer, a customer for which there was no pre-existing relationship, but you're also involved perhaps in helping design the order or in working with the customer to make sure that the furniture that they order is custom or is of a particular quality. Sometimes this is the kind of business that should be commissioned to you for quite a while after termination. Repeat orders of the same material should be commissionable to you. So there is a reason to seek out in the right case, not in every case, but in the right case to seek out language like this that enables you to get commissions beyond the date of termination. This is important because you're better off having no language in your agreement that talks about your right to commissions post-termination. Because if it doesn't say anything about that, then we are in a better position to seek to get paid those commissions under the law in most states. It's only if there is language in the agreement that cuts you off, that says upon termination, you're going to get paid commissions for orders that come in the next 30 days and nothing else. Then you're going to be limited. But if you have nothing in there about payment of post-termination commissions, then the law is much more in your favor because the presumption in most states is that those post-termination sales will remain commissionable to you since you procured that business. I know that's a lot. That's a little bit confusing. I appreciate that. What I'm saying is you got to be very careful about what the contract says about your right to post-termination commissions. And again, you want to make sure it's fair. You work for this company for 10 years, for 15 years, and they're going to pay you for 30 days after termination. Hardly a fair approach. Here's another approach. Look at paragraph B here. It says that in the event the manufacturer terminates, the concept here is that you're going to get paid for what they call a termination fee under this contract, but you're going to get a month's compensation based on the previous 12 months, the average commission payment that you got over the previous 12 months for the number of years that the agreement was in effect. So if you rep the line for 15 years, at least you know you're going to get paid for 15 months based on your average compensation. Something like that is a compromise approach to getting paid perhaps for life of the part, life of the product, but it's also much better than saying, okay, we're going to get nothing upon termination or only 30 days. Now, there's one other interesting approach here to termination clauses. This is a self-help remedy. The sales rep here got the language that said that the contract could be terminated without cause upon 30 days notice. What the sales rep here did, as you can see, is change that provision to say you can only terminate me on 30 days notice with cause. And then she wrote her initials there and she circled it and left room for the company to add its initials to go along with this. So what she did was she got the contract, she made this change, and with this change and her initials there, she signed the agreement and sent it back. Company never initialed it, filed it away, and it didn't come out, of course, until after there was a termination. And we took this case all the way through an arbitration proceeding based on this provision. And I can tell you that the arbitrator, a former judge, recognized that what the sales rep had done here was not accept the contract. She didn't just sign it and send it back with no changes. By offering this amendment to the agreement, she countered. It wasn't an acceptance, it was a counter. And they had the opportunity to reject the counter, and they didn't. They just filed it away. And then what happened after that? Well, both sides performed under the contract. For years, both sides went to market, both sides worked, they manufactured, they sold, they got paid commissions, and the arbitrator determined that meant this was accepted. Even though they didn't specifically initial it, the agreement had been accepted by them because both sides performed after the amendment was made. So you have a right to essentially negotiate through the entire contract negotiation process. I'm going to move on to non-compete agreements, which are almost never acceptable if they apply after the contract period. Certainly reasonable to include a non-compete during your contract period, but afterwards, 24 months after your agreement ends, a principal wants you to sit on your hands and not engage in any kind of competition. That's anti-American. And more states are stepping in and saying that's not going to be enforceable, even if you do sign an agreement like this. But my view on this, and what I always tell sales reps, is if they want even 1 month non-compete, they got to pay you for that month. That's fine. You don't want them to compete. You shouldn't be stuck not working, not making money for 24 months. Why? Because you had the privilege of representing their line, where you undoubtedly made them a ton of money, and now, for whatever reason, you're terminated. Doesn't say it has to be with cause, but for whatever reason, you can't go out there for 24 months to ply your trade. That's just not right, and it's indefensible. And most companies will back off of that if they even try to have an agreement like this in place. Let's talk for a second about the forum. This is not a clause that I understand many reps pay attention to when you sign your agreements with them, or when you shake hands and agree on anything. But there is a chance that your contract is going to have an unusual provision for dispute resolution, particularly if it's with an international company. But here you see language that says that the conflict will be settled not in a court, not under the court rules, but under the rules of the International Chamber of Commerce by 3 arbitrators to be appointed in accordance with such rules. Well, who belongs to the International Chamber of Commerce? Sales reps? No, that's an organization that manufacturers belong to. And language like this means 3 other business people are going to be appointed in accordance with the Chamber of Commerce rules, the ICC rules. That means you may not even get lawyers. You're certainly not going to get judges, but you're going to get business people whose point of view is often shared with the other members of the chamber, like manufacturers. You got to look out for provisions like this. And here it says that the arbitration is going to be conducted in Connecticut, even though the rep in this case was in Florida. So the rep doesn't have a lawyer in Connecticut. That means the rep has to try and find a lawyer who he doesn't know. And meantime, the manufacturer could be in his own backyard with rules that don't really govern most disputes, rules that aren't necessarily even-handed, because International Chamber of Commerce takes care of their own. So take a look at this. Make sure you understand the dispute resolution. And this isn't just limited to the chamber. Even if there's an arbitration provision, or even if you're able to go to court in a dispute, consider whether it makes sense. If you are the rep in Florida, if your territory is Florida or perhaps the Southeast, and you sign the contract in Florida, you're getting your commission checks in Florida, does it make sense that you have to go to Ohio or whatever other state they put in there to arbitrate or to litigate a dispute? Perhaps you want to push back on a provision like this. Here's a preferred method of doing this. State or federal courts, and you pick the state, and it could say your state, it could perhaps say the manufacturer state, or sometimes it says in the state of the party that files for arbitration or files suit. so that either party who sees fit to challenge the relationship could go into court and get relief. I word it this way because it is preferable to be able to bring any claim in court rather than arbitration. I could give a separate presentation on arbitrations. They are oftentimes perceived to be faster, less expensive, private. Plenty of examples where none of that is true. They usually are somewhat private, but you don't have a right to seal the record. But arbitration is very difficult for a lot of sales reps. If you go to court, after all, if you get a judge who doesn't understand how sales reps work, at least you have the right to go to an appeal. At least there is an appellate court. In an arbitration, there's virtually no right or a very limited right to seek an appeal if you get an arbitrator who doesn't understand the relationship between sales reps and principals, or otherwise makes a judgment that is inconsistent with the law. So we recommend having provisions to go to court. It's usually the manufacturers who push hard for an arbitration. And if you have to accept that it could work, it's a matter of where it's going to be held and what rules are going to apply to the arbitration. All right, so we're going to just quickly go over a few other things. In addition to venue, you want to think about whose law should apply to this case. Many states, if you don't know, many states have sales rep protection statutes. Those statutes enable a sales rep who doesn't get paid commissions on a timely basis to recover double, triple, or even quadruple the amount of unpaid commissions, plus attorney's fees, plus costs if you have to go to court. So it really carries a wallop if you have the availability to seek relief under a state sales rep protection statute. But sales rep protection statutes exist in 36 states, not every state. So oftentimes a principal will try to make sure that the choice of law is in a state that does not have a sales rep statute, a state like Delaware, or unfortunately Florida, or Nevada, states without sales rep protection statutes. The law should generally run consistent with where the sales rep is located or where the territory is located. So you want to try to make sure that you have some protection built in. There also should be the right, or this is something you'll have to consider, do you want to have attorney's fees provision in there? That means if you go to court, the prevailing party typically will have a right to get paid attorney's fees. There are pros and cons to having a provision like that in there. It's really something that should be discussed with your attorney at the time you go to contract. This is something we talked about earlier. If you're paid like an independent contractor, you got to maintain that independence. You're not going to get a check every month or every 2 weeks like an employee does. That means you're independent. Both sides should want to respect that and make sure that the contract isn't loaded up with provisions that would lead a tax examiner to look at the contract and say, no, 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 this is an employee relationship, not an independent contractor relationship. If there is a non-solicitation provision in there, that means a provision that says something like, upon termination of the relationship, the sales rep shall not make any effort to pirate away the employees of the manufacturer and shall not call upon, upon our vendors or something like that, that says you are limited in terms of what you can do post termination. All I'm saying is that that's not necessarily unreasonable, but it should be mutual. I don't want to see a sales rep organization get terminated and then the principal hires away the key man from the organization to come work direct. So you want language in here that protects both sides. And finally, what can be very important in the right case, you all have contracts. If you have written agreements, they talk about split commissions. They provide how commissions are going to be split, with 60% and 40%, or, the sales territory versus the design territory. All of that is perfectly fine and legitimate, but there should be a agreement that if I have the sales territory, but there is no rep in the design territory, the entire commission must still get paid. That means the sales territory gets paid 100%. Commissions aren't split with the principal. That's not a split commission. That is a withheld commission. So it's a very important concept that you have to make sure that the house can't argue that they get a split with you of your commission dollars. These are my overall recommendations. I know we're going to get to questions, but these are what I would recommend to you, if you can get away with it, if you can negotiate it. But I recognize that you don't always have the ability to negotiate like this. And sometimes there is the requirement that even though it's supposed to be a fair partnership, sometimes you have to sign the agreement as it is. Sometimes you're really not working together. You want the line that bad, or the commission rate is so good that you're going to have to sign the contract. And when you do, that's when you're going to find that it's not nearly as favorable as it should be. So I appreciate that. I recognize the risk that you're taking. I'm not trying to minimize it, but let's see if we can get to some questions. I hope I stayed on time, Steve.
You did. It was perfect. And Adam, thank you. It was incredibly insightful. So again, everybody, if you are on and you have some questions, I would love for you to go ahead and plug them into the chat. I especially wanted to thank you, Adam, for talking about the dangers of reporting and requirements imposed on reps, as well as the principles there, and specifically around some of the topics you talked about with house accounts, because that is something that we hear about quite a bit. And maybe while questions come in, I could ask that, and I think you've kind of hit on it already, but what is the best course of action for a rep who has brought in an account, establishes the business, grows the business, and then, maybe it grows to a point where the principal feels like it should become a house account, and it just is taken without much notice. I'm sure the answer here has to do with, well, what is your contract state? But what would you advise reps in that position?
Look, there are two kinds of manufacturers. There are those who feel like there is a partnership, and they want you vested in them, and they're smart enough to recognize that if they pay you a commission rate that's below market, or if they impose other conditions that their competition is not imposing, or if they try and take away accounts of yours that other companies wouldn't take away, that you're not likely to stay with them. Or if you do stay with them, as an independent sales rep who can decide for yourself how much time you want to spend on a particular line, you're going to spend a lot more time working for a line that treats you more fairly, or treats you in a manner that is more consistent with the norm, with the standards in the industry. So if you have a manufacturer who understands that, and who adopts those ideas, then they're not going to come to you and just take away an account that they know you have worked for years on, and spent a ton of your time and money to try and build up. However, if you have a manufacturer who doesn't give a damn about any of that, just says, why are we paying 4% on this line? We've had it for years. The rep isn't doing anything anymore. They're calling us directly. They're not going through the rep to place the orders. Let's take it as a house account and tell them to worry about finding new business. A relationship like that is obviously not one who values your services. And depending on how your contract reads, you may, if you're faced with a situation like that, you may decide that you're going to terminate the contract in response to taking action like that, taking away your best account or accounts. And again, depending on how your contract reads, you may be able to lay claim for those continuing commissions. Going back to what we talked about earlier, if the contract doesn't say that you're only going to get, they only have the obligation to commission you for 30 days post termination, if that language isn't in there and it's open-ended, you may be able to resign the line, go work for the competition, and come back against the company that you terminated to say, you owe me commissions for those sales that you have now decided to take as house accounts. So there is some relief available to the sales rep in a situation like that, depending on how the contract reads. And if it's an oral agreement, chances are there were never any terms surrounding an oral agreement that dealt with house accounts. The agreement oftentimes is simply you take Iowa for 4%, and you have an agreement like that, I can work with it. That doesn't give the principal the right to take away house accounts, and it certainly doesn't give them the right to cut off commissions on business that you generated for them in an oral agreement. So there are options available to a rep if faced with a unfair confiscation of your business, under the rubric that it's a house account.
Okay, thank you for clarifying that. And two-part question here. And they actually, maybe this is like a three-part question. I've got three that are kind of all tied together, but I'll ask the simple one. So if there is no contract in place, if someone is operating, if the sales rep is operating on a handshake deal, do you typically advise them to adopt a written contract? If, say, they're 5 years into this relationship, or is it better to just leave a little ambiguity in there and or rock the boat and roll the dice and try to get a contract in place?
Steve, I got to start at your premise. You started the question by saying if there's no contract in place, but in fact, if the rep has been representing the factory for 5 years, there is a contract in place. There is an oral contract, and you have a contract that can be enforced based on the 5 years of performance and the rules that have developed by both sides, the course of dealing between both sides. That adds up to contract rights that can be enforced. So you do have a contract. The question is, I guess, from there, are you better off trying to turn that into a written contract? And that is a specific question as to that relationship. If there are reasons to do so, if there, if there are new people in place at the factory and you no longer trust them, or you don't think they're going to honor their agreement, maybe there is a reason for the rep to try to formulate a written contract. Maybe there is a reason to call an attorney and say, can you help us prepare something? Because we want to get this relationship down in writing. It can work that way, but I'm telling you, there are plenty of times when, you're better off with an oral agreement that has things open, rather than inviting the house to try and tie your hands with a restrictive and perhaps unfair written agreement.
Okay, and thank you for catching my error in wording that question. But part two, and I'll preface it with a scenario. So part two is, how frequently should an independent contractor revise an existing agreement? And let's use the scenario. Say I have worked for you, my principal, for 10 plus years. But now there's a new sales manager in place that is demanding that, I have to submit these reports every day or every week, or update things into a CRM. And maybe CRMs didn't exist 10 years ago in that capacity, but it's a new set of requirements. But we hear about that quite a bit, where someone is in jeopardy of being terminated, or has already been terminated, because all of a sudden, like you said, there's a new sales manager. Something changed. It wasn't necessarily in the agreement, but now they're being held to a different standard than what was originally expected of them. So I wonder, can you be proactive, and how frequently should someone renegotiate a contract?
Yeah, I always recommend that for those reps who do have written contracts, that they go back and read them every few years to make sure that the actual performance is consistent with what the contract says, and whether any kind of proposal should be considered. But as a practical matter, contracts typically get amended not by sales reps, but by principals. The principal will say, we need a new contract, and they'll send you a new version, and they'll tell you to sign it and have it back to them within 24 hours. And that doesn't mean that you have to get it back to them in 24 hours. That's a situation where the principal is looking for a change. There's some provision that they want changed in the agreement. Maybe they want to change your territory. Maybe they want to take a house account that they didn't have a right to take before. Maybe there are other changes. But if you get a request by a principal to amend the agreement, the one thing is that the amendment is not in your favor as the sales rep. The amendment that they are proposing is in their favor. And of course, they don't have any right to insist that you amend the agreement. They're asking you to do it, even though they may not be asking very professionally. They're asking you to do it. And that creates the opening where, okay, they want to make a change to the agreement. So in exchange for that, perhaps there is a change that you would like to see made to the agreement. If they are asking you to give up a house account, maybe then that's an excuse to say, okay, well then expand my territory. I'll give you that account, but maybe I should get Tennessee now as part of my territory, which I didn't have before. So there are opportunities when an amendment is requested to try to negotiate further. To get back to the theme of this session, you have opportunities during the relationship to continue negotiating. And when they come to you like that, that's typically an opportunity to continue the negotiations. Now, sure, there could be opportunities that you see where you want to make an amendment to the agreement. It's a lot tougher when you have a signed agreement to convince the House that they should give anything more up that's in your favor, unless they're getting something in return. So it may be the same thing. If you want something and they want something, maybe you propose to make it so that both sides get something, because you shouldn't, under the law, you really shouldn't have just a unilateral change to the contract. To be enforceable, it really should provide for some benefit to both sides. So an easy way to do that, of course, is compensation. If the manufacturer wants to take away a right, they should do that in exchange for payment of X dollars to the sales rep. Then it's a valid change. But the idea that you're going to continue to represent us if you accept this change usually is not valid consideration. That's the kind of thing where you're being ramrodded. So I would suggest that you do have opportunities to amend, but it's a lot tougher to amend than it is to get the contract to your liking at the beginning.
Okay. And well, let's go back to kind of the core of what we first talked about, your basic principles when entering into an agreement. You have to, step one, read the agreement. Step two, read the agreement. But when it comes to negotiating, are there any recommended tactics or best practices that you would suggest for a rep, especially as we go we're 2 weeks away from the High Point furniture market? I'm sure principles will be, we actually have 25 companies who are advertising their current needs for reps through IHFRA right now. So I'm sure there will be new introductions, new agreements being made. So what sort of tips or best practices would you share with those reps that are getting ready to enter into those new agreements?
So these are companies that are already, they're going to come to the market, or they've already indicated that they have a need for a sales rep to take on their line.
Correct.
The sales rep is the new car that's sitting in the showroom. That car is at its maximum value when it's right there in the showroom. You all know that the moment you drive it off the lot, the value of that car plummets. The sales rep is at its maximum value before you sign the agreement. They're coming to you, they want you, they need you. So you're in your strongest position to negotiate at the beginning. You have to remember that even with big companies, you got to remember why you're there. It's because you have a great reputation. You have repped other lines that they are envious of. You have demonstrated a history of performance, and they want you on their team. They don't want you on a competitor's team. So even though it's difficult to jump in and say, how can you possibly think that I'm going to give you the right to take away any of my accounts as house accounts without getting anything back in return? This is your best chance to do that, to say to them, my other lines don't have this provision, or I would never agree to this in any other relationship. I don't know why you expect me to agree to it here. It's just not fair. If you want to put in something that says we can negotiate over a request to change an account, then you'll consider doing something like that. But you have to recognize that at the beginning of the relationship, typically, not in every case, but typically, is when you hold the best set of cards, when your vehicle is at the highest value on the showroom floor. Once you sign, you're never going to get treated the same way again, because now you're already part of the team. You're no longer a recruit. Recruits get treated much better than cadets. Everybody knows that. So you have the maximum opportunity, at the beginning And you should use that leverage to try to negotiate a contract so that it's much more favorable or more to your liking, rather than just signing the form contract that they give you. Now, I know what that sounds like. I've seen it before. They give you a 35-page, single-spaced form contract. They tell you all of our reps sign this. I don't know why you're pushing back. Well, that usually is not true. And if it's true, it just means that they have reps who didn't sit through a seminar like this and didn't get the benefit of this kind of legal advice. But you have an opportunity to push back. Worst that happens is they say no, and then you have a business decision to make as to whether or not you want to go forward with this relationship. So I would encourage you to read the contract, obviously, and then to decide, you're not going to push back on everything in there you don't like, but pick the biggest issues for you, the ones that you think are the most unfair, or the ones that would make the relationship the least desirable for you to be in, and try to push back on those. And you have to decide if they don't want to take any any pushback. I mean, if you're dealing with an Ashley, is that really a relationship that you want to get involved in?
Okay. All right. Well, thank you for that feedback. And I hate to say that, Adam, I've been very greedy with your time, and we are about out of time. We've actually gone just a little bit over. So before I say thank you and formally end this, what if the folks on this call, or that folks that watch this after the fact, have questions and they'd like to reach you? There it is. Okay. Just wanted to make sure I had your contact information that I could share with them. Would that be okay?
Right. Certainly.
Fantastic.
Anybody wants to email me or call me afterwards to talk about a particular situation, I'm here. Happy to talk to you.
Well, then in that case, I'm going to say thank you, everybody, for taking the time on a Friday to join us. Thank you, Adam, as always, for sharing your wisdom, your expertise with us, and making some time for us. I know you're a very busy man. This session is part of IHFRA's ongoing mission to advocate for, support, and empower independent sales reps. If today's discussion sparked questions about your own contracts or situations, don't hesitate to reach out to us, or better yet, Mr. Glazer here, who is truly the expert in this subject matter. We'll be sharing this recording in the coming days, so keep an eye out in the inbox. So thank you again. On behalf of everyone here at IHFRA, have a great rest of your day and a good weekend, and we'll see you at market in just a couple weeks. Thank you so much.
I hope it's a good market for everybody.
We do too.